name's Erin. I'm a family lawyer from Hugh Mavrina Community Legal Service. We're a legal service. Our office is in Wodonga, but we cover quite a wide area in northeast Victoria and southern New South Wales. So I myself attend outreach at the Women's Service once a week, and the WGV CAS in New South Wales twice a week. So today I'm going to do a presentation on family law with a focus on parenting matters. So I hope you enjoy. I'd like to start today just by acknowledging the traditional owners on the land on which we work and pay our respects to the elders past, present and emerging. So today is really general legal information. It's not to be used as legal advice for individual cases. Specifically children's matters, and I'll talk about it a bit, is that every child's different and the law for every family might have a different application. So we'll chat about that as we go. So if you want, you can speak to me after the presentation or ask questions we go. I've got the chat open, so I'll keep an eye on that as well. Yeah. So family law, we're looking at a national jurisdiction today. We're covered by the Family Law Act, which is a Commonwealth Law Act, except for WA, which often has its own rules. So if it's a WA matter, don't apply these things. They kind of do their own thing, but this should apply for Victoria and New South Wales. So what are we going to cover today? I'm going to start off by talking about the best interests of the child. That is one of the paramount considerations under the Family Law Act. Then we'll talk a bit about parental responsibility and care of the children. Then we're going to go through a couple of different agreements that we find for family law matters. We'll do a bit of an overview on the legal process before we go to court, and then once you're in court. We'll talk a bit about how family violence affects parenting matters. I'll give you some tips what to talk about what to do if a client has a parenting issue. I think I've also got some examples today as well, like I did yesterday, that we can have a go at working out. What I'm going to do is we'll start off with the best interest. So when considering care arrangements, the best interest of the child is the paramount consideration of the Family Law Act. It's the best place to start. There's a number of factors that makes up what is in a child's best interest. We call them primary factors and secondary factors. The primary factors are more important and more weight is given to primary factors. So the first factor that we talk about under the Family Law Act, under the primary factors, is the child having a meaningful relationship with both parents. So it's not about the parents, it's very much about the child and the child's meaningful relationship with the parents. The other factor that we look at is that the child be protected from physical and psychological harm and abuse, neglect and family violence. This second limb that I call the risk limb has more weight. It's kind of a balancing act. If there's no risk, then you'd put more weight on the child having a meaningful relationship. However, if there's more risk, then you'd put less weight on that, the child having a meaningful relationship. So it's kind of a balance. And no child's the same. So the reason that I guess we talk about best interests as we do is that what is good for one child or one family is not good for another. Because every family, as I'm sure you've seen, is different, and we kind of acknowledge that under the Family Law Act. So the secondary considerations that we look at, there's a number that the Act sets out, and I haven't put them all here. I like to start with the age of the child. So every child, depending on their age, might have different needs. So a younger child might have a stronger attachment with one parent and therefore can't spend time away from that parent for long periods of time. So you might not look at an equal time arrangement for a younger child, whereas an older child would cope better with more of an equal time arrangement. Other factors that we look at is like the health of the child. We look at family violence. The child's wishes is something that we consider as well. And the weight that we put on that again is dependent on the age of the child. The child's wishes, it's interesting. While important, it's not one of the primary factors that we look at. It is more of a secondary consideration. So while what the child has to say is important, it's not up in those primary two factors being the risk factor and the meaningful relationship factor. Other things we might look at, and I won't go through all of them, is a relationship with grandparents, the attitude of the parents towards the child, you can have a look at them yourself. Culture, religion, all sorts of things that we look at when we're looking at these secondary considerations. The next thing the court will do is look at parental responsibility. Parental responsibility is defined in the Family Law Act as all duties, powers, responsibilities, and authorities parents have for their children. So parental responsibility has to do with those major long-term decisions, such as around maybe education, maybe around medical issues or religion. Parental responsibility, there's a presumption that the court makes that the parents have equal shared parental responsibility. So those big decisions are made jointly by both parents. However, if there is family violence or child abuse, then the court might say that sole parental responsibility is appropriate. So it's kind of when we're looking at the Act, we go, okay, first, equal shared parental responsibility. That's the presumption. If that can be effectively rebutted because of risk reasons, then we'll be looking at sole parental responsibility. So the court then says, okay, if there is to be equal shared parental responsibility, the court then needs to consider both parents having equal time if it's in the child's best interest and it's reasonably practicable. So the court, in deciding equal time, it's not presumed. It needs to be in the best interest of the child. So that's those best interest factors we talked about before. And also reasonably practicable. Like an equal time arrangement, it's probably not going to be reasonable practical where one parent lives in Brisbane and the other parent lives in Melbourne. So, or if maybe the parents don't communicate well, then a equal time arrangement might not work either. So if the court says, okay, an equal time arrangement's not appropriate, the court would then look at a substantial and significant time. When we're talking about substantial and significant time, we're talking about time on weekdays, time on weekends, school holidays. It basically involves each parent having meaningful involvement with the child's daily routine. It doesn't mean definitively like, alternate weekends and some time on a, Wednesday. That's what it could look like. It could just be, a couple of hours on the weekend, a couple of hours after, for a dinner, and some time on school holidays. If the court says substantial and significant time's not appropriate, then we're then looking at basically what is in the child's best interest. So it goes back to those best interest factors that I talked about before. So it's a full circle. The court says what's in the child's best interest. Then it talks about parental responsibility. If equal shared applies, we're talking about equal time. If not equal time, substantial and significant time. If not that, then it really comes back again, full circle, to what's in this child's best interest. So we're looking, when we're talking about agreements in family law matters, we're looking at two main types. So there's the informal agreements and the formal agreements. When we're talking about informal, it might be a verbal agreement, a written agreement. It could be a parenting plan. Be aware, informal, they're not enforceable. So you can't go to court and say, I want these agreements enforced. They are easy to change though. Whereas you can have also formal agreements. So they might be court, or they are formal, are generally court orders, and they are enforceable, and they can be changed by further court order, but they are hard to change. I'll talk about them a bit more on this next slide. So parenting plan, what is that? It's a written agreement that's signed and dated by the parties. That's very important. If it's not signed and dated, it's not a parenting plan. It's developed voluntarily by the parents, but you can't go to court and have it enforced. So the pros of parenting plans: easy to change, easy to make. Cons, you can't enforce them. So your other option is court orders. So there's two ways to make court orders. One way is by application to the court. You put it to the judge. The judge then makes court orders. You have to go through the family law proceedings. The other way is if you and the other party have consent, you can basically turn the agreement into court order format. You file it with the court approves of it, and that then becomes consent orders. Benefits of court orders: they're court enforceable. If anything goes wrong, you can go back to the court and have them enforced. You can also be breached for not following court orders. Cons is that court orders last until a child turns 18. They're not easy to change. If you both agree, you can change court orders. If you're both not agreeing, it's more complicated then, because the court doesn't want you to come back to court every time you want to change court orders. You need to meet a threshold to go back to court again if you've already got court orders. So what kind of things would you see in court orders or a parenting plan? We often talk about parental responsibility, live with arrangement. So who does the child live with? Who does the child spend time with? We talk about how does phone contact occur or video chat time occur? How should changeovers occur? Like, should it be at the house? Should it be maybe at a public place? We might talk about special occasions, so birthdays, Christmas, Easter, those important days. How does school holidays work? Do we split it equally, or do we just continue on with the usual arrangement? We might talk about schooling or medical issues, like providing authorities for parents to talk to schools. We might talk about restraints. So restraining one party from using alcohol or doing drugs while the child's in their care or before the child's in their care. There's other different restraints that we might discuss and put into court orders or parenting plans. So this is a bit of an overview of the court process before going to court. So parents have lots of different options when we're talking about family law matters. What's important to know is that matters often for family law resolve without having to go to court. And there is a benefit of that. So, and I'll talk about it a bit, is court can be lengthy and time consuming. So what happens? So that it starts off, there's a family law issue. If the parties can then negotiate about that issue, they might do it themselves, or they might use a lawyer to negotiate with each other. If they can't reach an agreement, they can go to mediation. The court says you have to try mediation in children's matters first. You can get around that. So there are exemptions to going to mediation if there's been family violence, child abuse, or there's urgency. Now, if you go to mediation, though, you're not guaranteed that you'll be able to do mediation. The actual mediator has a discretion to decide also if mediation is appropriate, especially in circumstances of family violence. They might say, look, this is not appropriate, you need to go to court, or have a different avenue. So if an agreement's reached at mediation, then you can do the parenting plan and then transfer it later into court orders. If no agreement's reached, you then have the option to go to court. You might notice that I said if there's a family law issue, you can do nothing, and I'll talk a bit about that later. Sometimes we discuss, I guess, like, don't rock the boat. Mediation, and like if the other parent's not wanting to spend any time with a child, and you're going through court, then you're like it's a difficult process, and the other party then might they have to be served, they have to be involved, and you may not get the outcome that you want at the end of the day. But I'll have an example about that later. So this is a bit of an overview of an average court process. It can chop and change around, but what's important to note for family law children's matters is once you get to court, sorry, my lights. Once you get to court, it can take up to 2 years or more to reach that final decision. So from that initial application being made, like you might get through fairly quickly and it might be done in a year. It could take 2, even 3 or more years, you know, to go through this process. It really depends on the complexity of the matter. But matter can settle at any stage. I think I've read somewhere 3% of the matters only reach final hearing, and that it might be because it goes to an interim hearing, or there's a family report, and then the matter might settle then, so it doesn't need to go to that final hearing stage. So what happens through the court process? So a party files an application with the court, and then the other party has an opportunity to respond. So they will file their response documents. The court then will have a first mention. On that first mention date, the court decides, I guess, what needs to happen. There might be some discussion about should there be some interim time before we get to the final hearing? Should we get an independent children's lawyer involved? Should there be some psych reports done on the parents? Should there be a child impact report? So a child impact report is, it's like a family report. It's done by someone from the court who has experience in family matters. And it's a lot shorter than a family report. It's usually 2 or 3 pages, and they make recommendations on what should happen during, in that interim period. This may not happen at the first mention. It might be the parties can't agree on anything at the first mention, so then it might go to an interim hearing. The times between each of these dates varies, and it really depends on which court a matter is listed. So in Albury, we have the Albury Federal Circuit Court that sits, I think at the moment, 4 times a year. So you might have that first date, the first mention might be at that first, date, and then the next sitting might not be to 3 months down the track. And then Melbourne's similar. I think their waiting times are a bit longer, but every court is different. When I'm talking about, sorry, I don't know if I said, when I'm talking about court, I'm talking about the Federal Circuit and Family Court. So there's one in Albury, one in Shep, Melbourne, Sydney. They're in the larger suburbs. Albury is the main one that we deal with up here. So if parties can't agree, then it needs to go to an interim hearing. It might be, those matters there, the interim time, the ICL, that might happen at the interim hearing. If, parties still can't agree and they're looking at having to put it to a final hearing, then they'll go off to what's called a directions hearing, where we say, okay, this is how long the matter is going to be. These are the witnesses we're going to call. We might need further evidence, so we might then get the family report. We might, once we have the family report, go to mediation. If we still can't reach an agreement, then we're looking at going to a final hearing. Final hearings are where parties provide the evidence and get the opportunity to cross-examine the other party. A lot of what's happened before the final hearing is on the papers. So we provide evidence by doing affidavits. Once the final hearing is heard, you might not get a decision straight away. Sometimes the judge will want to have a think about it and could provide the decision a couple months later. So that's your average process, and it does chop and change around. It really depends on what needs to happen in the matter and the complexity of the issues. So how does family violence affect parenting matters? So family violence will affect whether mediation is appropriate. So that decision, if parties apply to do mediation, the mediator has that discretion to say that mediation is not appropriate. The family violence will affect decisions made about the best interests of the children and their safety. So particularly those primary two factors being the one parent having meaningful time with the child versus not exposing the child to risk of harm such as family violence or child abuse. The court, it will affect the court's decisions about parental responsibility. So the equal shared parental responsibility versus sole parental responsibility, where there's been instances of family violence. It will affect how much time a parent might spend with the child and the manner. So in more severe instances of family violence, then we might be looking at a contact centre or time being supervised by a family member. It also might affect how changeover takes place. So I've just had a question, does there have to be family violence? Does there have to be charges of family violence for it to be a factor? No, so the court will look at different evidence. So we might, things that we'd look at to work out if there's been a history of family violence is AVOs. We often subpoena police records to find out if there's police attendances at houses, at people's houses. We might subpoena hospital records if one party says that they've been to the hospital or the doctor. There's other ways that we can find out if there's been family violence. There doesn't have to be actual charges for that, for it to be a consideration under the best interest. So tips when you have clients that have parenting issues. I'd recommend that they get legal advice fairly early. What we find is that the early legal advice stops matters from escalating. Like, for example, if there's family violence, there might be a lot of controlling behaviour and they might be one party saying you can or can't do this. At least if they get the legal advice, then they know their rights, they know what they're allowed to do. Especially get legal advice if they've been served with a letter from a mediator. With the mediation, there are potential cost ramifications if you just ignore a letter from a mediator. There's also, if you get served with court documents, you really need to respond to those court documents so your evidence can be put before the court. Court documents, how do you know they're real? Make sure that there's a court seal on there. So there's a big court, usually it used to be a red seal, but now with the everything being online, like it's just this big seal that'll be on the documents, and there should be a court date. So that's really important, is to take note of that. There's also a timeline for parties to respond to documents once they've been served. So I would say encourage them to get some legal advice fairly quickly. I spoke about it before. Court orders last until a child turns 18 years of age and they're court enforceable. So yeah, just be aware of that. There are ramifications. So there are consequences for not following orders, and they're often, those consequences are set out on the last page. There's in the small writing that no one reads of court orders. Look, they could be anything from makeup time, or, you know, or worst case scenario, prison. But every matter's different. It depends, I guess, on the severity of the breach. So I've got a situation here today. So we've got Sam. So Sam entered a refuge with her 2 children recently. Sam has a full AVO against her ex-husband, for the protection of her and her children. Her ex has engaged a lawyer, and they've told her if she doesn't go to mediation, they will take her to court. Her friends have told her not to respond, as she has the AVO, and there is nothing she can do about it. What are Sam's options? What would you guys do, knowing, I guess, what we've just spoke about?
Look for the red seal before on the documents.
Yeah, if she gets served, yep.
Yeah.
Seek legal advice.
There is no documents yet. Yep.
Yep.
Yep. Legal advice.
I'm not sure if you went yesterday, but I would probably get a copy of the AVO would help Sam. The question here would be, can she do mediation? So what does the AVO say? So I guess the question here for Sam, like the risk she runs if she refuses mediation is that she could run a costs application for just ignoring the invitation to do mediation. At least if she, and I guess every client's different, but at least if she went through the mediation process, the mediator can then make that decision as to if mediation is appropriate. They might say, because assumably there's family violence here because she was entered a refuge, that there has been some family violence, so it might be that mediation's not appropriate. In saying that, though, there are different types of mediation. So just because you're doing mediation doesn't mean you're going to be sitting around a table discussing it. These days we have different formats, so it might be that you know, for family violence matters, that we have shuttle conferences, so they're not even in the same building. They both could be on phones in different towns. and the mediator shuttles between one party and the other to see if an agreement can be reached. But we've also got legally assisted mediation. So if you're eligible for legal aid, you can have a lawyer assist you, or if you can afford your own lawyer to attend at the mediation and to do private mediation, you might be able to have a lawyer assist you through that process. So there's a couple of different things for Sam to have a think about. The risk she runs in just ignoring the lawyer is that the lawyer might then say, okay, she's not willing to participate in negotiations or do mediation, then I'm going to go to court. As we noted, it can be a long process. It can be costly and time consuming. So court's not always the best place for clients to be. So that's a risk we have if Sam does nothing and just sits on her hands. So next we have Lisa. So Lisa and her ex have been separated for the past 12 months. Lisa's 2 children live with her, and she hasn't, and he live with her, and her ex hasn't asked her to speak to them since she ended the relationship. She has a 5-year AVO against him. Child protection were involved initially, but they're happy with Lisa's care of the children, so they've closed the file. They have told her that she needs to go to court and get custody of the children. A friend of hers also told her she needs custody. She's been told it's a simple process, but she's unsure if she should do it herself or see a lawyer. What suggestions do you have for Lisa?
I think I would tell her, I don't think there's any rush, especially if he's not reaching out and asking. I can see that in the chat, put leave it for now. I think getting some legal advice, there's no harm in that, so that if he does reach out to say, I would like to see the children now, she can kind of plan her next steps around what she would like to do. Not sure why the AVO is in place, but if there were some issues around that, she could also get some legal advice around if the children needed to be placed on the AVO.
That's great. So yeah, there's definitely a question here if Lisa should do anything. I just did want to note one thing. Custody we don't use as a term anymore. We talk more about who the live with parent is and who the spend time with parent is, sorry. It's not so much a term we try to avoid these days. So we've got some other clients, see a lawyer, yep. Ask for a support letter from Child Protection. Yep, so if they did end up in court, that would be a good idea. Or they could subpoena the Child Protection records is what might more often happen. Again, I think it would be seek legal advice. Don't rush it. That's it. He's not interested in spending time with the kids at the end of the day. If she goes through the court process, procedural fairness says she has to serve him with a copy of the documents. He has that opportunity to respond. He then could turn up at court and be asking for access. She could then be having a 2-year court matter on her hands. Whereas if she does nothing, there's that status quo. It's definitely, again, though, an individual matter. If the court orders do provide you, I guess, with some peace of mind, you might still, sometimes what happens is parties might want to change a name, or they might want to get a passport, which then makes it a matter that they might need to then go to court for. I say might, every matter's different depending on the background of it, depending on what state they're in. Like for births, deaths and marriages is depending on what rules we're looking at. Yeah, so he might, and the longer he leaves it, the harder it's going to be for him. Assumably with a 5-year AVO, there was a bit of family violence. So there might definitely be some risk concerns there. This is assuming, it's just a scenario. Okay, thanks guys, they're good comments. So what to do if you have a client with a family law parenting issue? Option 1, send them to us for legal advice. We do family law advice. We can also have secondary consults with you guys. In New South Wales, some other good options are Law Access and New South Wales Legal Aid, Albury office. There's also, so there's local practitioners who do family law privately. There's also ones who act on grants of aid. So the client would have to apply for a grant of aid. They can then assist the client with New South Wales Legal Aid funding them. There's a good list on our website of lawyers who act privately in family law matters and ones who provide New South Wales legal aid. So that's another good place to start. I've also just written link clients in with appropriate services to ensure they're well supported. So especially clients who've experienced family violence, they've got a lot of other things going on. Maybe they would benefit from some counselling, just other support might be necessary. It'll also help them, set them up for the family law matter as well. Yeah, because there's waiting lists. So for example, mediation, if they go off there, there's waiting lists, and that varies depending on which type of mediation service you're using. So like locally, we often send clients to Upper Murray Family Care. They might have a waiting list, don't quote me on this, but like 10 to 12 weeks. New South Wales Legal Aid, you've got to fill out the application, you've got to find out you're eligible. They also will have a bit of a waiting list. The other side of it with mediation is that they have to assess that the matter is appropriate for mediation. So they contact the other party, they speak with both parties and see if it's appropriate, and only then can the mediation go ahead. So there's a bit of a process that needs to happen before a party can go to mediation. And the same with court, it's not instantaneous. Like with court, they might have to try mediation first. If mediation's not appropriate, then they'll need to draft up their court documents. That takes time. You file it with the court. You might not get your first mention date for 6 weeks. It depends where you're filing and the availability of the court. Any questions? No. Well, that's it today. We've done like a fairly decent overview of family law. These are our contact details. If you're wanting to get in contact with us. I was just thinking another good resource is the Family and Federal Circuit Court website. If you're wanting to know, like, there's which documents need to be filed and a lot of that procedural kind of stuff, I would suggest clients get legal advice if they're needing to file or have a court issue. Thanks, Gillian.
Thanks so much, Erin. I really appreciate it.
Yep.
And your time yesterday too with the AVO session.
Good. Thanks for listening. I hope you're able to learn something new and take something away from this.